So this presentation considers the main approaches and the key decisions facing negotiators with respect to the legal and the institutional issues around a future WTO agreement on fisheries subsidies. And there are, we think, 4 key areas where decisions will need to be taken that are considered here. The first is around transparency and notification, the legal form of a future agreement, monitoring and review of the new commitments, and what dispute settlement rules should apply to the new agreement. Focusing now first on transparency and notifications. So the key decision here is, should the agreement require notification of elements or information beyond those members are currently required to notify under Article 25 of the Agreement on Subsidies and Countervailing Measures? And if it should require additional elements, what should these be? So as a little bit of background, Article 25 of the ACM, of course, already requires members to notify all subsidies as defined in paragraph 1 of Article 1 of the ACM, which are specific within the meaning of Article 2 of that same agreement. So notifications of subsidies currently are required to include the form of the subsidy, the amount that's provided, and its policy objectives, for example. So on top of these requirements, there are several proposals on the table that call for information to be notified about, for example, the capacity of the fleets that are receiving subsidies, the status of the stocks fished by the fleets that receive subsidies, vessels and operators fishing in areas beyond national jurisdiction, for example, and potentially IUU legislation and any determinations that are made, particularly at the national level. And an important point to make here is that the purpose of notifications is, at least in part, to help members monitor each other's compliance with WTO agreements, which obviously means then that the content of the transparency and notification requirements is going largely to depend on the scope of the disciplines. So, for example, notifying vessels or operators fishing in areas beyond national jurisdiction will really only be relevant if there are specific prohibitions included on that topic. If there are, or assuming that a possible prohibition on subsidies to IUU fishing is based on determinations by national governments, then it might be useful for the transparency provisions to include requirements for members to notify their relevant legislation, and particularly to notify any determinations they make. And beside the content of all of these various transparency provisions, I think it's also important to note that some developing country members and least developed country members have highlighted the need to ensure that requirements for notifications aren't more burdensome than necessary. And so I just flagged that there may be the potential for organized cooperation here with other organizations like the UN Food and Agriculture Organization, to whom members already notify some fisheries data. So that's transparency and notifications very briefly. The second key decision relates to the legal form of a possible agreement. And essentially, these discussions seem to be focusing on 2 key options for the incorporation of a future agreement into WTO law. The first is that the agreement be structured as an annex to the ASCM agreement, and the second is that the agreement might be a new standalone treaty that is incorporated as an annex to the Marrakesh Agreement establishing the WTO. And an example of that approach might be the Trade Facilitation Agreement, for instance, which is structured that way. So one key consideration perhaps in choosing between these 2 options is the extent to which members want to incorporate concepts from the ASCM and follow its broad structure. So annexing the new agreement directly to the ASCM could allow members to adopt most of the ASCM approach, including not only basic elements like the definition of a subsidy and the notion of specificity, but also details like the rule that prohibited subsidies are deemed to be specific. But if the agreement takes only some elements from the ASCM but is otherwise quite different, then a standalone treaty text might make a bit more sense. But again, it seems the discussion or the options there are relatively binary. It's been narrowed down to these two options. So that's one of the simpler legal and institutional questions. There are a couple of key decisions to make around structures for the monitoring and the review of this agreement once it's completed. And the first key decision relates to what institutional structure should administer this new agreement. And the proposals so far envisage more or less three broad institutional options. The first would be to use the existing WTO Committee on Subsidies and Countervailing Measures, potentially just by expanding its scope to include review of this new agreement. Another option might be to create a subsidiary body under the committee, under the Subsidies and Countervailing Measures Committee. And a third option might be to create a new committee specifically to look at the new Fisheries Subsidies Agreement. And the second key decision, which is linked to the first in some respects, is to define the scope of this committee and what its roles and responsibilities would really be. And so proposals so far have mainly focused on reviewing notifications, reviewing compliance, and reviewing commitments made in the agreement according to agreed timeframes, if there is that kind of a discipline in the agreement. Another idea to raise is that it's possible that this committee could serve as a forum to raise specific concerns if they emerged, if a member believed that another was subsidizing the fishing of an overfished stock, for example. And in a similar vein, this committee or subcommittee could serve as a forum to review technical assistance and capacity building needs of developing members. So there are various different roles, responsibilities, jobs that could be given to this committee to help monitor and review and administer the new agreement once it's concluded. Moving then to the last set of decisions, and potentially the more complicated ones, there are three different areas of key decisions that are currently on the table in the area of dispute settlement. So how would we like the dispute settlement process to apply to the new agreement? The first set of decisions concerns remedies that might be applied in the agreement. The second set of decisions considers a concept called standard of review of the new agreement, of the new obligations, and I'll go into that in a bit more detail next. And the last area of key decisions concerns disputed maritime areas. So the first set of key decisions under dispute settlement relates to remedies that the agreement might allow members to take to address the negative effects of a subsidy or to address perceived non-compliance with the agreement. So under the Agreement on Subsidies and Countervailing Measures, members currently essentially have two options to address the trade effects of a subsidy, because that's what the current agreement focuses on. There's a multilateral option through the dispute settlement mechanism, and there's a unilateral option through the use of something called countervailing measures. And the question in this context is whether members want to allow for multilateral solutions, multilateral remedies through dispute settlement processes, and whether they want to allow for unilateral remedies as well. And that's an open question. So if, as I think the working assumption is that there will be multilateral dispute settlement that applies if to any disputes that arise under this new agreement. Assuming that that's the case, one question that's emerged is whether there should be a special consultation mechanism that applies in addition to the existing consultation mechanisms under the WTO's dispute settlement understanding. And some members have suggested that this procedure would operate in addition to what's already provided under the ACM and the DSU, and that its objective would be to allow members to exchange information on fisheries subsidies, and potentially to voluntarily rectify any harmful effects of subsidies, minimizing reliance on formal dispute settlement processes. And the idea is that given the environmental focus of the disciplines, it might be useful to have this preceding consultation before an issue goes to formal dispute settlement. Now, if the agreement allows for unilateral remedies, the question is how could these be designed? How could they be calculated? And so as a brief reminder, under the existing ACM, the ACM allows members to impose additional duties on imports pursuant to an investigation that shows their domestic industry suffered something called material injury. And the question is whether some sort of similar unilateral remedy should be envisaged in a fisheries subsidies agreement for a member whose fishing industry is affected by a subsidy program or whose stocks are affected by somebody else's subsidy program. And there are a couple of challenges with defining what a unilateral remedy would look like in this context. One might be defining how a material injury that would justify a unilateral response might be calculated. In the context of a fisheries subsidies agreement, some notion of injury would have to take into account general environmental or sustainability considerations in addition to purely economic ones. And besides this conceptual challenge, some kind of unilateral remedy would have to be designed in a way that could offset the negative effect of a subsidy on a stock, not just on a member's own fleet. And this might require quite a different approach than simply imposing additional duties on imports. It would have to be something that addressed the environmental effect of the subsidy. And now that's quite a complicated set of questions. So again, the first key decision, should the agreement focus just on multilateral remedies? If so, how could these be designed? And would there be value in having an additional preceding consultation process? And if the agreement allows for unilateral remedies, how might these be designed to take into account the environmental focus of the agreement? So the fourth and fifth key decisions. The fourth decision relates to a concept called the standard of review. And the decision here is how, if at all, should this new agreement articulate a standard of review that should apply for different obligations. So to explain the context a little bit, several proposals that we've already discussed envisage that the future WTO disciplines would require that subsidies be amended on the basis of decisions taken in the context of fisheries management. So for example, under the IUU disciplines, a determination made by a coastal state member could trigger an obligation for another WTO member to remove its subsidies to the offending vessel or operator. So members are thinking about the extent to which WTO dispute panels should examine decisions taken about subsidies under the new agreement, and the extent to which they should examine decisions taken in the context of fisheries management that would trigger subsidy obligations. And essentially the depth with which a panel looks at a member's decision is referred to as a standard of review in the negotiations. And so the general rule, the general approach is that the depth to which a panel examines a member's compliance with the agreement depends on the nature of the obligation that's been agreed and exactly what that obligation requires. So to go back to the IUU example that we discussed previously, the idea on the table is that IUU determinations would need to follow certain due process requirements before they trigger a member's obligation to remove subsidies. And the way that the text is currently being discussed makes it clear that that obligation relates only to the administrative process of how the determination is made, not to the validity of the determination itself. And so that's one example of what you could call a standard legal approach to standard of review, which is that you draft the rules so that the extent of members' obligations is clear, and the panel looks at the rule and essentially examines only what a member is required to do and no more. So there are several, in addition to that sort of standard approach, members are also considering if, and if so, how they can ensure it's clear what elements of a fisheries management related decision could be reviewed by a panel. And so there are several options being discussed, if not necessarily written into the text yet. So most members seem to converge around the idea that they don't want panels to engage in what's called a de novo review, or a full review of all of the substantive elements of an IUU determination or a stock assessment, for example. Instead, there are some different approaches that panels could be guided to follow. You could have an automatic recognition of an assessment or a determination. You could have a procedural review of a member's decision, and that seems to be the direction the IUU discussion is going. Or you could ask a panel to conduct a review that's limited to the scientific basis for a member's assessment, for instance. So there are different ways that members can draft their obligations that would guide a future dispute settlement panel in how far it looked at a member's decision. And here are some examples of what those approaches could be. And these perhaps are approaches to bear in mind as you look at the text. Does the text and does the obligation clearly focus a member's obligation and focus a future panel's attention on a particular degree of obligation?